So going into a little bit on IP, for the filmmakers, game developers, advertising creatives in the room, and they're using AI tools for like storyboarding or visual effects or whatever it might be, what practical steps do you think they should be taking to avoid potential IP disputes in the future? Jared?
I mean, I think there's a few practical steps. Some of it is the contracting aspects, to the extent you can, have indemnity or, other contract agreements that can provide, good protection. A lot of it's education also, understanding how you're using these systems, what they do, and using it in appropriate ways. And so you can take steps to mitigate your risk of any infringement by what you're prompting or how you're vetting your outputs or your own, way of using these. Some of it's also the, taking advantage of the way the law is developed and which aspects are protectable of your own IP. And so making sure, if you're creating prompts and it's your own novel input, you're using your own, imagery, your own other inputs. These are aspects that you actually can own, and so you might want to document what you're doing. You might even want to proactively file for copyright registration, have a presumption of the validity of your own rights, or file for patent rights if you're innovating in ways. And so you want to consider kind of the landscape of what you're doing, be educated about it, and take advantage of the various aspects of the law that can protect what you're doing and not just be defensive. You are going to take some risk using systems where you don't fully understand what it is, but you want to do as much as you can to mitigate that risk and position yourself well.
Yeah, I've got a couple of interesting points there. Prompts is one that we've talked about previously, and I'm interested as well first of all, how important are prompts from an IP almost dispute perspective? And also, you mentioned maybe taking some kind of record. How forensic should people be with keeping records of what they're prompting and what parts are human created, what parts are prompted and AI assisted?
Yeah, I mean, those are great questions. They don't have clear answers, and depends on what you're doing. I'll say how you prompt the system or how you're using generative AI to create works is going to impact what rights you can protect. Just sort of the way the law is developed, you can't get copyright for purely AI created works, but you can get copyright for works that are AI assisted for the human creativity that goes into it. And similarly, you can't get a patent for an AI invention, but you can still patent inventions that you make using AI for assistance. And so how you're using these, what you're inputting, if it's your own inventive work, if it's your own creative expression, those are the parts that are protectable. And so if you are creating using these, there are benefits to some record retention to show that. That doesn't mean I think you need to be retaining everything always, and that comes with its own can of worms if you're litigating and everything that comes along with it. But when you are creating things, that can be useful evidence. I think it's also important not to be misusing prompts. I think that there's a lot of things you could input where you're increasing the risk, and a lot of times the terms you might have with these different systems are going to go to you not doing anything that is going to create challenges with their guardrails, because these systems are designed to, I think, in large part prevent risks for copyright infringement, things like that. And I think you have to be selective in how you're prompting them to make sure you're not creating additional risk there.
Yeah.
And so you want to be cautious.
Yeah, go ahead.
Yeah, I mean, even though we're like a fast-growing company and pride ourselves on opening up new use cases and being super innovative, we've entered this sort of scale-up maturity part of our journey, and we view our guardrails as a huge part of our competitive advantage. So if you're talking about prompting, like we have a tool called Voice Design, where you can, with text, create any voice you want. So you say, I want a sort of 6-year-old British pirate with a gruff voice, and that voice can be created. If you were to type in, I want the voice of Mickey Mouse, the prompt would be blocked. Same with our music products. Your inputs, which are your text prompts, are scanned for copyright. So if you say, I want a song in the style of Adele, that'll be blocked. It'll automatically suggest language for you that might make a song along those lines, British female, beautiful, voice, but it won't let you. It won't let you prompt with that. And same for, we allow you to upload tracks to inspire a song that gets created, that gets scanned via third-party copyright scanning tool. So like, we try to keep our customers out of trouble in the same way that we're trying to keep ourselves out of trouble, and we actually view that as a huge advantage. And just to give one other example before I move on, we have a voice marketplace with about 15,000 voices. Any of you, I don't know if anybody here has a voice in the 11 Labs voice marketplace, but you can upload a voice clone, put a bunch of parameters around it, and then derive passive income from people's use of your voice. We paid out about $15 million to voice actors who are in the marketplace thus far. Those voices they're vetted, they're verified, somebody has consented, they're being compensated, they have control, and offering that to our customers, again, is we view that as a huge part of our competitive advantage. So I think it's on companies like us to create safe tools, and then it's on the customers to ensure that their employees and in turn their customers are also using them safely.
Yeah, I love that it's licensed and it's already ready for action. So we know any of those voices, it's fine to go. Those people know that their voice is manipulated in AI. That helps a lot.
I wouldn't say manipulated.
Well, what do you? Enhanced? I don't know. But I think that is a selling point for me. Anything that's got proper permissions going into the system, it makes it so much easier. But the prompts aren't always guarded, or there aren't blockers in every tool. And when I've got thousands of employees, I have no idea who's doing what. And so again, it comes down to training. What can you prompt your system to do, and what is appropriate? And we still haven't, I don't know the answer yet. What do we do with these prompts? Is it better to save them? Is it better to have them go away? And I talked to Alex, they have a product, you can talk about that. But I just don't know the answer yet. Is it better to have them or not? But for now, they exist, and beware. Whatever you prompt may come back to haunt you in a lawsuit.
And just for there's no, I think, answer at this point for where the fine line is for what to save. But we're probably going to see more and more lawsuits, alleging that, hey, they're using this voice in a way that they shouldn't have, whether it's under an IP claim or right of publicity or what. And there's going to be gray areas where, someone is asking for a pirate voice and that they're not asking for a voice that sounds like Johnny Depp or something like that. But if the system gives a voice that someone's going to accuse, even if it's designed with guardrails to not sound like that, you're going to end up with cases where judges or juries are trying to decide how close is this? Is it too close? Is it similar enough? And having those prompts showing, especially with the training, or even just having the training, the record that, hey, we teach all our employees to make sure they understand that we want the prompts to not output the specific stuff. And we don't ask for specific voices because, that's creates problems. Like that responsible use, having a record of that, whether it's from the prompts or from training, I think helps to mitigate the risk companies will have.
Yeah. And also, I guess, reduce the flagrancy of infringement risk, right? If you can show that we did not try to do this, then that will help with the damages potentially as well. Alex, you mentioned the music models, and obviously 11 Labs has recently entered the music space, and you've been striking a lot of those deals with the music rights holders. Music is an industry that has historically been deeply shaped and bruised by technological disruption. When you have been speaking with the music industry, have you found were they initially skeptical and quite cautious and conservative? And if so, how did you sort of convince them? And I guess it's going to go back to education again, but I'd love to talk a bit more about that.
Yeah. So when it comes to music, and generally when it comes to creatives, 11 Labs has pursued the path of partnership. We didn't put out a music model that's trained on all the music in the world and get sued by the major labels. I think that was a big part of our value proposition in our negotiations and conversations with the music industry. Like, we're here, we're going about it the right way, we're trying to work in partnership with you, we're trying to create new revenue streams for you, let you, have a role in shaping the product that's trained on your data. And don't get me wrong, we've gotten a lot of skepticism notwithstanding that approach, but that's certainly been very helpful and has paid dividends. I think that the music industry, almost more than any other industry, knows how to deal with dramatic technological changes. Like, there's just so many technological changes that have completely transformed who gets paid, how they get paid, how the business operates over time. And I do think that most of the music industry is taking a cautious approach, but their approach isn't, we're not messing with this stuff at all. Yeah. They just want to make sure that they mess with it the right way. And again, so it's slower moving than a company like us would like. But I do feel like we have good partners on the other side who understand that this can be a real value add.
Yeah, I think we're seeing something interesting as well. We've got IP owners, rights holders that are suing AI companies while simultaneously doing deals with them, the same ones, right?
Yeah.
Do you think that eventually all roads will lead to licensing? And if that is the case, does that risk favoring the sort of larger rights holders who can afford to take litigation?
Yeah, I mean, I think Nick, you know this world better than I do, but I think like the ability to sue is a really useful hammer for any company in any business, and part of how monopolies become monopolies is by suing everybody. And so I think that lawsuits will always be a tool to flex power for rights holders. But I think ultimately the rights holders are looking for new ways to engage with their fans, new ways to, as I said, new revenue streams to open up. So I think it's kind of a combination. I think what you just said will continue. Continue to see litigation as people try to protect their rights, and we'll continue to see more deals as people try to maximize them.
Okay.
I'll also just add to that. I do think there's an interesting angle now as some of the, at least the outer bounds of potential fair use or legal theories for use of these materials are being sorted out. And so I do think some of these cases are for, it certainly is in part, leverage of their IP. I don't mean to minimize that. But we're also kind of settling what the rules are under current law. I mean, the law always evolves with new technologies, and so some of that's being sorted out, and how some of these first cases get resolved, I think will guide a lot of the strategy going forward.
That was going to be one of my questions to you, honestly, was you obviously had a slew of different IP cases last year in particular, more to set this year. Do you think that we're only at the beginning, or it sounds like you think it's starting to find its feet a little bit as to the settling of the position?
I think a lot of kind of the counseling and the strategy is settling in from the early guidance we have so far, but we certainly don't have decisive guidance. We have different, in the U.S., different circuits, different courts, and we don't have much finality in any circuit on some of these issues. You have a lot of precedent that lets you predict, but unpredictable things can happen in the law. And I do think, just at the rate that AI and the technology is changing, I think things are very different today than they were 2 or 3 years ago. And I think anyone who's kind of predicting where we'll be in 3 or 4 years on the technology side is, has a little more confidence than they probably should. And so we've got to fit the law and the technology together. And this, just like the music technology changing in other ways over the last 2 decades, like it's going to continue to change, but so does the law. It's how it works.
There's been a lot of discussion about collective licensing. Do you think collective licensing is a potential solution for these AI companies to obtain the rights? Is there a world where that could work?
It would certainly make our jobs easier.
Yeah.
And it is, music, I'm not sure how many of you are in music or have dealt with music rights, but you have anywhere from 2 to 25 owners of an individual song, which makes acquiring the rights really hard. We also have a audiobook product called 11 Labs Reader, and in Reader, we're trying to acquire from publishers books. There's a single owner from whom you can get tens of thousands of books. Not an easy negotiation, but remarkably straightforward as compared to music.
Yep.
And so if the music industry really wanted to be maybe it was a little bit more of a willing participant writ large with AI companies, that would be an incredibly helpful thing.
Right.
Will it get there? I don't know. What do you think?
No.
No.
I don't think so.
Because they don't want to make it easy.
No one wants
Yeah.
to. No one. The rights holders don't like collective licensing. They don't like the societies. They want to. That's why a lot of them have withdrawn their rights from these societies, because they want to be able to, and they think they can maximize their value by directly contracting. But it puts someone like you or your companies in a difficult position, because you have to have thousands and tens of thousands of licenses in place instead of a few. But it's an interesting point. But to a similar point, I think governments around the world and lawmakers are trying to strike a balance between the interests of innovation and tech companies and the interests of creatives and artists. Do you think a balance can be found from statute and from legislation, or do you think it's inevitably going to have to side with one of them? Jared, do you want to go?
Sure. I mean, to kind of take a step back at first, I mean, the whole purpose of copyright law is to promote creation, to promote creators making music, art, everything. And I think that there are competing values here. That you have creation by individual artists, but generative AI also enables creation by others. It enables other types of art. So I don't think it's one versus the other. The goals of copyright can favor both. And so trying to craft any legislation that accomplishes that necessarily, I think there's a tension if you're going to have either compelled licensing or fair use or anything like that kind of baked into it. Because of that, there's been, I think, fairly slow and deliberate legislative developments. And here there might be state level attempts at aspects of this. It's kind of hard to see, but I don't think there's a consensus on a way to do that well, and so it's going to continue pushing for the different I think stakeholders.
My past life was in government, including in Congress and working on legislative affairs in the Biden administration. And the last thing that I'm going to do in my current job is wait for legislation. It's not going to come. And so I think what we want to do as a company, again, taking the partnership path with creatives, is develop the fair frameworks ourselves. It would be great if we had a effective legislative body in this country that could find the right middle ground and allow companies like us to then more easily get the deals done that allow us to innovate. Not going to happen, so we just have to chart our own path, and that's what we're doing.
Yeah, there'll be industry organizations that will come together and put their own rules together, just like the IAB and IAPP. All these organizations are making their own frameworks that are fair, letting both sides or all stakeholders have a say in it, and then cutting it down the middle. It's pretty much how you can do it.
Okay. Romy, you obviously worked in advertising a long time. Even if you do everything right, you do all the licensing properly, you do all the labeling properly, etc., do you think there's still a reputational risk currently in using generative AI for campaigns?
Yes. So we would never, and I don't think it makes sense to just have it developed within AI and then push it out. You need to have a human in the loop, even for ownership purposes. if the you want to own the product, you should have a human in the loop, because you can't have a copyright in something that is created by a non-human or a monkey, because that was the case.
That's right.
So you want to continue along that path, and I think that's the way it's going to develop for now.